Let's face it, when a Supreme Court position is on the ballot, only a few people care. Either the candidate runs unopposed, or the election is more of a beauty contest than a real election, because usually it's just personalities, not principles, that are at stake. This year it's different. This year it matters. Washington voters are being asked to make a dramatic choice. I'm sure you've heard about the McCleary case, the one that's trying to force the legislature and the governor to agree on a budget that would dramatically increase the funding for K-12 education. Most of the attention is focused on the extreme remedies the court has proposed, threatening to cut off all funding to the schools if the legislature and the governor don't comply. But in this series of videos, I want to show you that there is something even more dangerous than the immediate crisis, which is bad enough. The court is claiming that your rights, the ones guaranteed in the state constitution, don't matter nearly as much as what the court claims is a positive right to education that it claims to have found in Article 9, Section 1. We need to get our court back to its proper role in interpreting and applying the law, not making it. But we also need a clear message that we, the people, want our rights back. I'm David DeWolf, and I'm a candidate for Position 1 on the State Supreme Court. This is the first of a four-part video series that explains what is at stake in this election, a choice between a court that respects your rights and one that replaces your rights with its own idea of how you should live. You may think I'm just exaggerating things to get your attention, but if you stick with me through this series, I think you will agree with me. This first video deals with our state constitution and how it was designed to protect your rights. The next video, Part 2, deals with how the Washington Supreme Court in the McCleary case turned this idea of rights on its head and put the rights created by the government ahead of the inherent rights your government was created to protect. Part 3 tells how the court has lost its balance, how it held the whole state of Washington in contempt and imposed a fine of $100,000 per day. Finally, Part 4 describes how the court's threat to cut off all funding for Washington schools puts the children of Washington at risk just because the court is unwilling to admit it was wrong. So let's start with a review of our state constitution. Most people know more about the federal constitution than they do about our own Washington state constitution. Of course, there are important similarities. Both our nation's founders and our state's founders believed in limited government, that government exists by the consent of the governed and needs checks and balances to prevent any individual or branch of government from becoming all-powerful. A constitution grants powers to the government, but it conditions the exercise of those powers on the respect for our rights. We need government to do things, but we're nervous that once it has power, a government will use that power in disregard of our rights. We depend upon our courts to enforce the Constitution, to act as a leash that will restrain the government from going beyond the powers we have given it. Our state constitution makes this particularly clear. Unlike the federal constitution, which only added a Bill of Rights by amendment, our state constitution started with a Declaration of Rights. Article 1, Section 1 says clearly, "All political power is inherent in the people, and governments derive their just powers from the consent of the governed, and are established to protect and maintain individual rights." In other words, our rights come first. The government is allowed to operate only to the extent it is protecting and maintaining our rights. You may think this is just another boring civics lesson, but I want to show you how far the current Supreme Court has departed from this original understanding. The McCleary case is alarming not just because it has led our state to the brink of a constitutional crisis, not just because it uses threats to shut down our schools or take other drastic remedies, but because it fundamentally misunderstands our state constitution and the origin of our rights. McCleary wouldn't end if the legislature and the governor bent the knee and gave the court everything it wanted. It would replace a government of the people, by the people, and for the people with a government in which the courts decide what rights they are going to give you. McCleary doesn't hide the ball. It first claims that it has found in Article 9, Section 1, a right. Now, Article 9, Section 1, which is labeled the preamble to Article 9 on education, simply says, "It is the paramount duty of the state to make ample provision for the education of all children found within its borders, without preference on account of race, caste, color, or sex." That's it. But the court says this creates a right on the part of every child or parent to an amply funded education. Remember Article 1 of the Constitution, which is the Declaration of Rights. Is it listed there? No. But the McCleary court says that this one sentence should be interpreted as creating a right. Not only is this a right, says the court, but it's a special kind of right, a sort of super right. It's special in two ways. First, it is paramount. It takes precedence over any other right. And it's a positive right that actually requires the government to act. So even though the Constitution doesn't call it a right, it actually trumps, if I may use that word, all of the rights contained in Article 1, the Declaration of Rights. I think you can sense that there has been a serious misreading of our Constitution by the McCleary Court. My next video expands on the far-reaching consequences that would flow from the McCleary Court's claim about a positive right, and how it would turn our Constitution upside down. But I want to end this video by pointing out the weakness in the court's argument. If the authors of our Constitution thought they were creating a super right, why didn't it even rate mention among the 30 different rights they identify in Article 1 of the Constitution, our Declaration of Rights? Could it be it's not really a right at all? Please log on to my website, DeWolfForJustice.org, and follow me in the second video in this series, The Constitution, Leash or Cattle Prod. I'm David DeWolf. Thanks for watching.